We're live.
We are live, okay. All right, committee, this is Senate Finance, I believe this is the 9th of February. And we're still recovering from the lost meeting yesterday because we were on the floor. Today, we're going to go through the Department of Financial Regulation housekeeping bill. Because as I told you, that because the timing and drafting didn't get in time for a bill number, so we've been asked if we would consider attaching it to the captive insurance bill. There is insurance in this bill. I said we consider it, and so we're gonna walk through what is in there. In the past, DFR has been very religious about making this housekeeping, no major policy changes, and it's usually gone through quite easily. So we're gonna start out. Okay, I have got Aaron first, then Emily, and Emily. Do you wanna go first? Okay, it's your dog and pony show, so bring them up, whatever it works.
Good afternoon, Emily Kosicki, Director of Policy of the Department of Financial Regulation. Thank you for considering our housekeeping language along with the captive still. We appreciate that, and we were planning today to just walk you through sort of high level what the proposals are in our
Do
housekeeping.
we have a copy of that?
Yes,
Okay,
Maria sent it
is
to
that
Zane.
up on our website? I didn't see anything up there earlier. But we could put that up that everybody could look at it.
Was it the amendment?
Yes.
The bill itself, the DFR housekeeping. Wannabe bill,
Maria mailed it at 12:37.
we could put that up then, everyone, you can start.
Okay. So the first few sections are sort of more technical, purely cleanup type of language, or at least that's the intent. The first section, it adds to some existing law about civil penalty authority within our Securities Act. There's language that's added at the end of 5604D, which states that in accordance with the 8 VSA section 24E, the commissioner may increase the civil penalty amount by not more than $5,000 per violation for violations involving a person who's a vulnerable adult, as defined in 33 VSA 690234. This isn't new authority for the commissioner. This is existing authority that exists in Title VIII as it's referenced there. It also is referenced elsewhere in the Securities Act, which is 9 VSA 5603 B2C, which is a civil enforcement.
Yeah, mine isn't loading. Maybe you could share, can you screen share?
Sure.
It will be up in like 30 seconds.
Okay.
My iPad is doing its not loading thing again.
I just like to see it on my screen. My apologies, trying to
Oh,
follow.
no, no.
No, it's much easier to follow this.
I think if you start refreshing, it should load.
Okay. Under off, let's see if I can-
Emily,
Okay.
are you working off of the one that Maria sent us or a different one? I just want to make sure I'm
From
looking
Maria.
at the right. Okay.
Yeah.
So, keep going.
Do you have it now? Okay.
Yeah.
So again, this isn't a new authority that we're seeking. It's really more of a cross-reference because this authority is laid out in Title VIII, Section 24, and it's also referenced in 5603 of the Securities Act. This is also dropping into 5604, just to make it very clear.
What's it going to do?
It gives, well, this isn't, again, it's not new authority, but
Right,
it's
but why,
existing.
what's it gonna do in this new? Why do we need to put it in this new?
Basically, our legal division felt that this cross reference here would be helpful because it also appears in a different section for enforcement authority under the Securities Act. So this would really just avoid any confusion or someone missing that heightened penalty authority exists for this civil penalty authority right here. If someone was like looking specifically at this section of the Securities Act, so really, again, a cleanup cross reference.
That's legal people say it belongs there. Okay.
The next, section 2, this is making some changes to the, and it's a wordy title because we keep adding uses to this fund, but it would, change some wording that would, the intent of this change here is really on line 10 and 11 on page 2. And it's making clear that the commissioner can direct up to 15% of settlement amounts into this fund for any enforcement action. So right now, the wording says for a state securities law enforcement matter, we want it to be clear that, you know, if there were an insurance enforcement matter or a banking enforcement matter, they could also deposit into this fund because the uses of the fund aren't limited only to securities. And we used to have all divisions depositing into this fund, and then a couple of years ago, when the wording was being tweaked, it inadvertently got limited in wording to securities. So we just, again, want to make clear that any of our divisions can deposit into the fund. And just for a refresher on this fund, it's used for a variety of purposes. It originally was created for our financial services education special fund, which again, we use that for providing important financial services education and outreach statewide. We've added victim restitution and whistleblower award uses to this fund over the recent years. So again, it's available for a variety of uses.
Okay. Okay. So that is, I finally got my computer to load. So that was section 20 that you were just doing?
Yes.
Okay. And special fund reserve, okay. Okay, there are questions?
Yeah. And you mentioned, I thought you were saying that securities had been taken out and that we were putting it back in. I don't see that in the text.
Inadvertently, securities, so on line 10, where it says a state securities law, and that's struck.
Yeah.
Inadvertently, it had been limited to state security settlements, so it was appearing that only securities enforcement matters could deposit into the fund. So we're suggesting that limitation be struck, and it made clear that any enforcement matter within our jurisdiction may direct
Okay.
a portion of
Providing
settlement proceeds into.
where the money can come from. And
Exactly.
where, okay, yeah.
Is that what this is doing though, or are you just, are you taking state securities out of?
Securities would be included within our suggested language. So any enforcement matter within our jurisdiction, which includes securities. Yeah. Section 21, 22, and 23 all are directed at the same issue, and it is for notice requirements or for certain PNC I'm sorry, for notices for certain PNC policies, and so it's just again pulling out each specific section where notices are required. Property casualty, sorry. So we require and will continue to require that notice be made by certified mail, except for cancellation for non-payment of premium. Notice can be by certified mail or certificate of mailing, or we'd like to suggest adding any similar first-class mail tracking method that's used or approved by the U.S. Postal Service, including intelligent mail barcode tracing. And that is, we go further to say that a certificate of mailing doesn't include a certificate of bulk mailing for what would be permissible here.
bulk mail package.
So you couldn't
Yeah.
do that, that doesn't meet this requirement, but what we've learned is that there is a sort of newer tracking system called IMV tracing used by the US Postal Service that is I sufficiently reliable. And so this is a type of tracking method that insurers are using or hoping to use. I think that they are already using it and we want to allow that use by statute.
No, notice cancellation by email.
No,
Good.
yeah,
So
so it's
tried
not,
that several times.
yeah. So it still has to be, first class mail tracked, and this is just one method of tracking, that I guess is comparable to certified mail.
Okay,
There's no electronic equivalent of certified mail.
Not that we're suggesting here.
it hadn't been suggested in the past, I'm not sure if it's by the department. But bills have gone through and there's been objections as to you could have left your job and wanted to change your email.
Right.
You wouldn't get it.
It's not gonna be on paper.
It's just the tracking of
Yeah.
it, yeah. That's it for really sort of the purely technical or cleanup items. Moving forward, we have three model law proposals. The first two are NAIC model law proposal that Deputy Commissioner Brown is going to walk through.
As I understand, we either adopt the NAIC model law or we risk losing our certification.
And that's true for one of these. So
Yeah.
one of them is
Yeah.
an accreditation standard, one of them is not. But we think that it would be good for Vermont to adopt it for uniformity. And that's the pet insurance model, which will come after
I
this
heard
first
that
one.
was the new, last year we did travel insurance and this year we're gonna professionalize pet insurance.
Yep,
Okay.
that's the goal.
All right. Should I just jump in, Emily, to talk about the holding company changes?
Yes,
Okay, great. My name is Emily Brown. I'm the Deputy Commissioner of Insurance. I'm sorry I can't be there in person. So as Emily Kosicki said, this section is model law. So this was adopted by the NAIC, which is the National Association of Insurance Commissioners, and most recently has been approved by the NAIC to be an accreditation standard, which, as was said, is required for us to kind of participate and regulate the insurance market in our state. So there's kind of two parts of this, actually three parts of this model. The first one is a group capital calculation, which was most recently adopted by the NAIC, and this applies to holding companies. So it essentially provides financial information.
Billy,
I'm
can you
sorry.
tell us what a holding company is, just so we're all on the same?
Yeah. So if you're thinking about it structurally, you have an insurance company which is independent, and then when there's a holding company involved, it could be a group of companies, potentially not all insurance companies, with a holding company kind of owning or affiliating with multiple insurance companies or multiple different companies. So if you think about it, it's just a group of companies that get together and can either share services, ownership, all different types of ways that this can be structured. And there's been law on the books, I think, since the 1970s regulating holding insurance companies. So this is just really an expansion of that existing law that we have in statute. And these expansions are more related to financial pieces. So instead of more focusing maybe on process parts of holding companies and how the companies interact, these changes will actually start to look at how the finances of the companies are interrelated and looking at the risk that may be posed by market stability, and also how risk is shared among the companies.
Okay, so in some ways, that's similar to a captive insurance company. So there is some sharing of risk between the different companies or affiliate companies that,
There can be sharing of risk, but I wouldn't say that's a blanket uh, factor in a holding company arrangement.
okay,
So the group capital calculation, I was saying, it provides financial info about all the companies across the group. It quantifies the risk across the group and provides transparency into how the capital is allocated among the different companies. And it also allows regulators to understand to what degree insurance companies might be supporting the operation of non-insurance entities. So again, the group capital calculation is a new tool for regulators to use to really assess, how risk is spread across the companies and capital. So the other piece of the legislation is the liquidity stress test, and this is a reporting requirement. So liquidity stress tests are already happening among a holding company, and this is a reporting requirement that the holding company has to make to insurance regulators. The next section of the holding company changes, a large portion of it is confidentiality provisions. So essentially there's right now, because the group capital requirements and liquidity stress tests are new, they're being added into our confidentiality provisions, and we're clarifying that the results of the liquidity stress tests and the group capital calculation are confidential and not subject to disclosure.
can you give us a page that you're on?
I'm sorry. Yep. Let me pull it up. So
6 and 7. 6 and 7.
is it 6 and 7? I'm sorry. I'm on my iPad, so I'm having to flip between screens. But if someone is in the, maybe Emily, do you have it? Do you have the page number handy?
Are you on the confidential treatment?
Yes. Yep.
That's page 38 of 148.
38, okay, so we. Okay.
Yeah, it's a pretty large section and very detailed. And I'll be honest, I'm not a CPA or financial expert, so there's a lot in there that goes to the reporting requirements and different aspects of each of the sections I talked about. So if there were more specific, detailed questions about capital requirements and the liquidity stress test, I would like to provide maybe some written testimony on that.
I use, since I think I'm presenting this bill, a written summary.
Yep, I can do that.
So far I was saying this is an NAIC requires.
Yeah.
Actually, they're gonna wanna know what it does.
I can do that, and the NAIC actually has a great little one-pager that I can send along. But we'll send that, and then I can also send more of a kind of a simpler version of all the sections.
That would be wonderful.
No problem. All right. Before I move on to pet insurance, are there any other questions about the holding company model changes?
I don't think anyone feels comfortable enough to ask a question. I've got confidential treatment on 38. Have we done that? On page.
Yes. So that's part of the Model Act, and that's essentially codifying that the information, the group capital calculation information that's submitted to the department, as well as the liquidity stress test information, those will be held confidential by the department.
Okay, so where do we pick up the next section?
All right, pet insurance. Emily, do you have that page handy?
It is chapter 149. And I have low battery, so
It's page 48 of 148,
it's on
or 45, I'm sorry.
45 of 100.
45.
Section 28.
Okay,
All right.
Madam Chair, yes.
you have a question? I have a question.
So
Okay.
I do feel uncomfortable asking questions because this is 148 page that I've seen before. My question really is how has this language been out there floating around in the ether for anybody that does understand what this is doing to speak up and reach out if they want to inform or highlight attention on anything that might be of concern?
Yeah, so
Yep.
this
So,
it's existing law that is being updated, and so we have already holding company act model law in our statutes, and this is an update that was adopted in 2021 by the NAIC. Is that the right year, Emily?
I have December 2020, but yeah, it probably went into effect in 2021.
So that's when it was approved, and I think it was more recent that it was voted to be an accreditation standard that all states had to adopt these updates to the previous version of holding company model. So, you know, it has been out there. There are other states who are and have been working on updating or adopting these updates. Everyone will have to adopt
And
these
these are
updates.
not small mom and pops. These are large, sophisticated with a legal department whose job it is to follow regulations, so.
Correct. And so, you know, this is adding in, like Emily said, those new stress tests and calculations to our existing regulatory framework for holding companies. And so we'll definitely follow up with the written testimony and sort of one-pagers that Emily mentioned that can help it be a little bit more digestible, because I find it hard to understand. We also have our insurance company licensing and examination team, who the director there might be able to speak to some of the tests in more detail and how we look at those if you'd like to ask those questions.
Okay. Okay. So we're on to pet insurance.
Yeah, pet insurance, a little bit simpler. Um,
The
so
problem
this,
is controversial thing in India.
yeah. So this is also an NEIC model. Obviously not an accreditation standard, so we don't have to adopt this. But I think the department thought it was a good idea to, since it's really codifying our current practices. So right now, pet insurance forms and rates are filed with the department and we review them. The issue right now is that we don't have really any set of statutes that directly apply to pet insurance. So what the model does is it will give us, you know, the backing for all of the positions we're taking right now with pet insurance. So while we have the authority to review our forms and rates right now, this will lay down in statute notification requirements, add transparency to the policies, and really just codify existing positions that we have for pet insurance and really have been using, I'd say, for the more, 5+ years. And so, and I can talk about, do you want me to talk about the specific sections, or I can answer any questions?
We have never done pet insurance, so just kind of walk us through what it is, what you regulate, or what this.
Sure. Yep. So pet insurance, you might think it's a health insurance product because it's really covering, illnesses of your pet or accidents. But it's treated by the state and really nationwide as a P&C product. So a property and casualty product. And what it does is it provides people a certain amount of money if their pet gets injured, and they have to pay, a bill. It provides, kind of similar to health insurance, provides the policyholder with a certain amount of money to pay towards that bill. And so, and depending on the policy design, it might cover the whole amount, it might cover a percentage. But again, this bill lays out those requirements that insurers have to give notice to consumers and clearly disclose how much the coverage is, how much it costs, what it's covering, what it's not covering, if there are any waiting periods. So it's really for your pets. If you want to buy this, and if something happens to them, then you have coverage to help cover any unexpected expenses.
Okay. Don't see any questions at this point, so, Randy has.
What's a pet?
What is a pet? That's a good question.
So I
Yeah.
didn't see the definition.
There's not a definition. I think that would really be up to the insurance company. So most of the time, I think
You know,
these are
an
written
rhinoceros,
for,
example, that might have
Yeah.
different needs than a pet cat.
yeah. So that would really be up to the insurance company. So when you apply for this product, if you said in your example you had a rhinoceros, it would be up to the insurance company to decide whether they wanted to write you a pet insurance policy. We don't regulate the underwriting standards for these products, so it's really up to the insurance company to decide what kind of animals they want to cover under this policy.
Yeah, it might be more expensive if you had to fly your rhinoceros before.
Yes,
Three things, yes, okay.
One of
right.
my colleagues here suggested perhaps a pet rock.
Well, they wouldn't need much health insurance, so,
Yeah,
okay. But I think pet has the usual and traditional thinking of something that lives in your house that is not human.
right.
And by
Yeah.
definition, and, likes you to pat them.
I know, there's that, but it's just the fact there's no definition.
Yeah.
Would concern me.
No, you have a point.
I will give you a homework assignment, and you gentlemen can write a definition, and we will submit it to the insurance company.
We did discuss that, you know, internally, reviewing the model, and we noted that fact when we talked about, you know, farm animals and again, what would be treated as pet. And again, like Deputy Commissioner Brown said, ultimately, it would depend on the policy and whether the insurer, you know, agreed that the animal you were applying for coverage for was a pet that they would underwrite.
Would they
So,
normally have in effect some sort of an application or,
Yeah.
or you just check a flag and buy a pet insurance policy for any household pet that you had?
you'd apply for coverage,
And
you
they would
know,
normally ask you, I assume.
they would ask you about the animals that you're looking to get coverage
So
for.
if it's a 12-year-old cat, or
Exactly,
2-year-old cat would make a difference in price.
exactly.
So they'll ask you about your rhinoceroses and decide if they want to do.
The Supreme Court justice challenged to define obscenity.
You know,
Said,
see.
I know, I want to see it.
There are people that have taken calves into their home and raised them. There are people who have pet rabbits that run the house like a cat. I think the insurance company gets to decide if.
Yeah.
There's no general liability for, or, you know, general insurance for cats. You have to apply and tell them what you have. And they set the rate based on risk.
In my bohemian years in Greenwich Village, there was a guy who had a pet rat.
Oh, yes. I sold a house with a whole cage full of pet rats. It really freaks some people out. But yeah, they had 4 or 5 rats in a cage, and they were pets. They look a lot like gerbils, but they were good. So, okay, so we're leaving it to the insurance company to determine what is a pet. I assume if somebody challenges that and says, we've been through this with the service animals. And I guess the airports have finally determined that a peacock is not a service animal, can't go in the airport. And there will be some issues like that, and the insurance companies, I guess, will define what they'll do. Okay. Okay, so after we decide what a pet is, what are we going to insure them for?
So essentially it's how whatever is in the policy. So sometimes it could be, you know, the vet bills, it could be a percent of the vet bills, it could be expenses related to any illness or accident that, or I think orthopedic too, that could happen to your animal, but that's really going to be laid out in the policy.
So the advice is read your policy. So you know what you're insured for.
Right.
And this also would have requirements for an insurer to disclose, again, what's covered. There's requirements in here that you must put, you know, certain information on your website, disclosures of policy information. So this does provide some important, in our view, consumer or policyholder protections, because that information has to be clear for what is included and what's not, so that they really know what they have coverage for, what they're purchasing.
Because I'm on section B of 7153. So nothing in this chapter shall in any way prohibit or limit the types of exclusions pet insurance may use in their policies, and it goes on, such as chronic conditions, congenital anomalies or disorders, hereditary disorders. So you got an animal that comes from a long line of animals with chronic asthma, breathing difficulties. They could say no. They could say no. Yeah, if this, they just aren't assuring that, because that would be continual medical care. This is more accident. Yeah, it's something, pre-existing conditions, I guess. Which somebody's would like to have that taken out, I'm sure. Okay. But they could cover it, is the cost. That's
They
the
could choose
insurance
to.
company's choice.
Yeah.
But they are allowed to determine that they will not, insure jumbo ends. I.e. rhinoceros. Okay. Have we had issues with pet insurance?
I wouldn't say, are you asking if there's any trends and complaints, or if we receive a high volume of complaints? No, there's really not a high volume of pet insurance complaints when you compare to other lines of insurance. I think, again, because we haven't had a statute in place, there might be questions around what are insurers required to cover, what are they required to do? So those types of questions we get a lot. And so we're hoping that this, can alleviate some of those issues. But we don't receive any higher volume around pet than we do around other lines.
No. Fraud, okay. Any other questions? Think we're ready?
Oh, she's
We've been
all
through
over
it all.
here.
Can I have one more thing just about the pet provisions, is we have been, in addition to working with other states, on this model language, through the NEIC process, the pet insurance industry was also involved, through that collaborative drafting process. And we have specifically been in touch with them at DFR, NAPIA, I think it's the National Association for Pet Health Insurers or something like that. And so, we did talk to them about this, generally stuck to the model with a few Vermont deviations that we felt were important, or matched up with their existing practices. And so the industry as well is looking for this model to be adopted, because it provides them greater consistency among states and predictability for what standards they're going to hold to.
Okay, and this is an NAIC model,
Correct.
which we don't have to adopt for.
Correct. It's not an accreditation standard, but more states are looking at adopting it. It's a relatively new model. And so a number of New England states have adopted or are working to adopt it.
We found in insurance that the greater the consistency, the easier it is for everyone. Because if your dog breaks his leg when you're on vacation in California, you should know, if your insurance, if it works there, or California has different standards. What to expect, so. Makes it easier to license. Okay. Then we're done.
Do these policies roll over at the end of the year?
Because they're pets, essentially. Oh, this is a serious question, sir? I'm sorry, I thought you were just trying to be funny.
It's hard to tell.
Pet policies roll over at the end of the year.
Oh, they would be subject to renewal provision.
Right. Mm-hmm.
Oh, okay.
He's
Friday.
confused by
Yeah,
that.
yeah.
Okay,
No, he acts like that all the
anyway, we have another one in here, insurance. About the cows that ate the metal, yeah. Would it be this kind of pet, right? Their insurance didn't cover something this,
Yeah.
is there an insurance policy that would have covered it with layers?
I'm not sure, and I'm looking at Emily here for one a friend. I'm not sure if there's like a type of farm or livestock policy that could have applied.
We heard that they
Yeah.
didn't have insurance.
Yeah.
They had insurance, all the insurance companies would have battled out a settlement and
Yeah.
they would have been left out. It's been suggested we might form a captive for farmers, but I don't think we're going there. But I'm just wondering, would it must be more of a farm animal, working animal.
Yeah,
Insurance, and I'm sure they're out there.
yeah. Do you know,
I'm not actually sure. I'm not actually sure. So I would have to, maybe someone in industry would know, but I'm not sure what types of policies would cover, like, if you had a farm, I'm sure there is coverage for cows and livestock. I just don't know what those look like.
Okay,
we'll go back and look at it.
just since we're working on how to protect people when some business doesn't have the correct insurance, and actually it turns out everyone in this case did have insurance except the person that was damaged. But because their insurance didn't cover this, and I'm just wondering, that's because they couldn't afford, the no copay insurance kind of thing, the platinum plan. And, if they had the funds, they could have upgraded, because that may be something that's worth on.
Okay.
But I don't think we're gonna do all of that this year, but it's just an interesting. Would help, I guess, if this isn't a once in a lifetime kind of situation.
We can do some research.
It's like all pets except for cats.
Okay, committee, any questions on any of this? Pet insurance? Okay. We don't regulate price, so we can't ask you what it's gonna cost. So we're back to Aaron?
Yes.
Okay.
Good afternoon, everyone. Aaron Ferentz, Deputy Commissioner for the Banking Division within DFR. Thank you for having me.
Have you been here before?
I testified on the credit union deposit bill.
Okay.
I can't remember last week or week before.
Yeah, okay.
Yes.
So you're familiar with it?
I'm familiar with you. Good to see you all. So the portions that I'm going to talk about start on page 58 of 148 in that bill. Ultimately, what all of the, that's 90 pages or so, that is what we're proposing to do is to adopt another model bill. It's in relation to a company called, or a type of company called Money Transmitters. Did you have a question?
You just said adopt because it's pets.
Oh,
Sorry. I'm trying to make life funny, so.
You did Friday.
It is-
It does, I think it's too warm, there is a form of spring fever going through the committee.
The sun's out.
exactly.
That is a rare occasion,
Yeah.
and it's above freezing,
Warmed up a little bit too.
yeah. So,
So yeah, I use the term adopt for the model bill, but it is already an industry that we regulate. We've regulated money transmitters for 10 years plus. A money transmitter is a company, think of Western Union, where you're gonna give money to them today and they're gonna deliver to someone around the world, across the country. It's expanded over the years. It now covers companies like Venmo or PayPal, and you're electronically transferring money, but you're still not a bank. They're not otherwise exempt, so they are interacting with consumers, either sending money or receiving money for them. Most recently, we had the foresight in 2014 to add what we call stored value. We regulate the store of value. And what that actually encompasses is virtual currency. So certain specific types of virtual currency activities require you to be licensed as a money transmitter into the market. Now, we regulate all of our licensed entities in the banking division sort of through chapter 72, which has all of our general licensing provisions. That's sort of the first part of that language, starting on page 58. And then also the money services businesses, the money transmitters is regulated through chapter 79. The way this bill presents chapter 79 is that it looks like it's, I think the term is repeal and replace. Because we wanted to reorganize existing chapter 79 to include this language, and there are other entities like a check casher not affected by the model bill that we regulate through that chapter. It was easier just to sort of strike it all and then replace it with this new language. So it looks like a lot of the bulk of that information is stuff that's already in our purview and our regulatory oversight. Any questions so far? So this model bill itself has been already adopted by 14 other states. It's also been introduced this year in 11 others. So other states are sort of on board with these changes. Just a couple other good facts. There is no definitive federal oversight here. I'm not sure if you're paying attention to the press with FTX or any of those other bankruptcies. You know, the SEC says they have oversight. The Commodities Future Trading Commission says they have oversight. There's not one set of standards, so it's really left to the states to make sure that they are regulating these activities. The model bill itself was actually developed in conjunction with industry participants. So in 2021, when CSBS, which is the sort of banking equivalent of NAIC, sort of the national group of banking regulators, got together, they asked industry participants to help develop the provisions of the model bill, and that's what are in there currently. Let's see. In addition to those general themes, the model bill had an optional provision for virtual currency companies and activities. I mentioned before that we had already added some of those activities to Vermont state law. And other states may not have adopted the virtual currency portions. For the most part, we have elected to, where the model was stronger and provided better oversight, we've adopted those provisions within this bill. In other situations, we've gone a little farther, and that's really from the lessons learned that we've experienced with the crypto bankruptcies. So, yep, yes, it's Celsius, Voyager. We have staff that's been really leading a lot of those efforts just because we're really concerned about Vermonters and assets that they may or may not have had on those entities.
Yeah. Last time, a year or so ago, I know they were still trying to decide if cryptocurrency was a banking product or a securities product. Sounds like we've kind of gone in the direction of banking.
That's sort of, I don't know that this changes total policy for DFR. There are still instances where cryptocurrency may fall under the oversight of the securities division, and maybe Emily could speak more to that. When we're talking about money transmitters in relation to virtual currency, it's really when a virtual currency company is buying or selling, one of these regulated entities buying or selling virtual currency from a Vermonter for the purposes of money transmission. So they're another solution that adopting this will help us with is that there are a number of really complex models that companies try to employ to avoid regulation. And what this bill does is allows us to more succinctly and accurately hold them within our regulatory umbrella to ensure that we are able to oversee their activities appropriately. There are some things that are not in the model bill that we have asked to change. I'm not sure how many of you have seen these out in the marketplace, but there are Bitcoin ATMs, we call them as kiosks, where you can go in and take cash today and buy Bitcoin or other virtual currencies with it. As you may understand, that is actually an activity that's very ripe for fraud. So we have lots of public cases right now where fraudsters are directing victims to take out lots of cash from their bank, go to one of these machines, turn it into Bitcoin, and then direct that to the fraudster at whatever Bitcoin address they use. What we've proposed to do is Right now, the registration of those kiosks is included within our normal ATM registration requirements that would apply to a bank or a credit union. We're taking the Bitcoin money transmitter ATM kiosk language out of that without touching that. And we're incorporating these requirements into chapter 79 because the company that operates one of these kiosks would also have to be a licensed money transmitter. To further help deal with the consumer issues from the scams, we propose to limit the daily transactions that a consumer can do at a company's ATM to $1,000. So that's language that has also been adopted. Well, I should say, Connecticut has adopted language which limits the transactions per day at an ATM kiosk as well as California. In addition,
To 1,000.
I believe Connecticut is 2,500 and California's is 1,000.
And that's per individual or per transaction?
That's per company that has Bitcoin ATMs in Vermont. So,
Just Bitcoin.
right,
So that kiosk can only process that total amount? Or is that per transaction, or is that in a given period of time?
so I could only get, right now, the greatest number of these machines are the Coinstar machines in grocery stores. They actually have this component where you can turn the coins into virtual currency. So I could only go to Coinstar machines anywhere in Vermont, and there's 30 plus of them, and do $1,000 per day at all of them in total. They would, the company would be forced to sort of aggregate the data and know that I have already done $1,000 at the one in Barry, so I couldn't go to South.
How does it identify you?
There are requirements of money transmitters that follow something called the Bank Secrecy Act.
Mhm.
And those are regulations that require customers to provide identification to a bank or a credit union. And those same requirements for customer identification apply to money transmitters as well.
Does the Bank Secrecy Act go to that low a number? Or why did I think it was 10,000?
There are a lot of different requirements in the Bank Secrecy Act. The $10,000 would be if you are bringing cash in or out of a bank.
Yeah.
But absent the $10,000 threshold, a bank is still required to positively identify who their customer is for $1. Okay, so they have to establish that I am Aaron Ferentz before I can open the account. And it, sorry.
That's for opening an account. Can you do a transaction though without opening an account? For example, in this case, you're doing a money changing transaction, like you're going into a bank and buying a money order or buying it. You have to do identification there if you're not an account holder with the bank.
Yes, there are other requirements that deal with electronic transactions within BSA, which also require that sort of identification of who the customer is. That law is really designed to combat money laundering, et cetera, et cetera. It's very handy in financial crime cases as well. There are two other protections for the ATM kiosk area that we propose here. One would be to limit the amount of fees that a company could charge me for selling me Bitcoin through this process. It's $5 or 15% of the transaction, whichever is higher. Right now, there is no limit, so lots of people are getting really, those fees are really high. And then the final sort of public policy or consumer protection area would just be that it would require the company to disclose any additional hidden fees that may be involved in the transaction.
I'm looking at Senator Brock because he's been following junk fee proposals at the federal level. And I don't know if that would originate in economic development since we do consumer protection, but looking for lots of places to make those fees less hidden.
Yes, great idea.
Is that overall something that?
Popularity of protecting people who are doing Bitcoin deals,
Right.
probably not high
Yeah.
amongst the public right now.
Right, right. I mean, just, back of the envelope analysis, when we were talking about through some of these issues is, like. With some of these providers, Bitcoin would have to increase in value 50% before you would even make any profit on that transaction. There were so many fees. They were, the company was selling from their own account and not disclosing what the markup was. Very, very manipulative practices. In our other areas, we do regulate a lot of fees, like in lending, there are some restrictions on the fees that companies can charge, so that is something that's sort of important to us.
Well, if there are any thoughts the department has in the junk fee area, which this would, going outside of your area and the FR regulations, you might just let us know. Okay, this is something that we might consider.
Sure. For sure. I didn't prepare to go through my section of the bill line by line. We can certainly get someone here who has a lot more of that expertise. It's fascinating stuff, for a Friday. I think that's a yes. Are there any questions or? Did I speak too fast?
I'll just restate what I sort of asked before, and I think I heard the right answer. How long has this language been out on a website that is being considered for adoption this session over the next week or two?
So the Model Act itself language has been in place since 2021. We originally proposed this in
It did never come out.
It did never
We've been
come out.
talking about this within DFR for well over a year. It's been public through CSBS, the model provision since 2021. And then like this specific language has only been public since right before this hearing. So the DFR specific provisions around digital assets are unique, but otherwise it's model law that's been out since 2021.
Correct. And as I indicated, industry participants were heavily involved in the development of the language to begin with, so it should not be a surprise to them.
Just as a follow-up comment, I'm naive. This is 148 pages of legalese that I just saw for the first time today. So I'm trusting the public process that if there's concerns or anybody with wanting to bring attention to this language, that they're following this closely enough to raise concerns. But I have no concerns.
So, that is the other issue, the issue that I always question situations like this. Who opposes this and why?
Crypto folks, I think that those kiosk ATM owners and companies and providers will probably be the ones that have the most to say about it. They won't like that we want to limit the transactions per day. They won't like the fee limitations and the fee disclosures. I believe that's what they testified in Connecticut.
Well, I would think, when you talk about fees to do a transaction of $1,000 a day maximum, I would think some would say that's quite low.
Correct. It is sort of arbitrarily low, I think. Like I said,
Particularly when you've gotten positive identification as to who you're dealing with.
Sure. Unfortunately, I think the ultimate issue is that once that money is delivered to this Bitcoin ATM, the consumer's lost it forever. So if it is with a fraudster, it is gone. If
you give him cash, he's lost it forever too.
That's correct. That's correct.
So why is that different?
Well, it's harder to give a fraudster that's in Kuala Lumpur $15,000 in cash. It's much easier to give them $15,000. Instantaneous. And there are situations where it possibly is retrievable, but you cannot count on that.
And when you started out, you talked about fraudsters who would encourage you to go buy $20,000 worth of Bitcoins. If you put in 1,000, is there any way to know? How do you know when you buy Bitcoins where they are? How do I find out that I've been cheated and that I don't have $1,000 worth of Bitcoin or 10,000?
Sure. So the way Bitcoin works is that you have a wallet, sort of a virtual wallet, which is holding the the electronic data that is your Bitcoin. So you're buying that Bitcoin, and then the fraudster is telling you to send the money from your wallet, my wallet, to their wallet. Once that money, or once that Bitcoin is in their wallet, I no longer have control of it. It is essentially gone. And that is forever.
And you send it to their wallet, please back up. Because you think you're paying for a transaction with Bitcoin?
With the scams that we're seeing, it's the old romance scam of like, hey,
Oh.
you know, I'm over here,
Yeah.
we've been conversing, I think you're the love of my life.
Okay, so it's the same.
The same old
stuff,
scam.
new
that you
technology.
actually-
You don't have to put it in the mail, put a stamp on it. I could just.
Yeah.
Yeah, so I could just go down, I could put $10,000 in Bitcoin, push a few buttons, and that Bitcoin is.
I saw another scam that came out in Franklin County within the last month, in which the same scheme was done, that was done with gift cards. Go to Hannaford's and buy X number of gift cards,
Oh,
you
yeah,
know, that are payable to whatever store, and then that's the way transmitting the gift card.
no, I won the, what was it, the Publishers Clearinghouse, and what color Ford Bronco did I want delivered this afternoon? And I'm telling the guy, I'm a state senator, and I'm, you know, and I told him all of this up front. He just kept talking, and it got down to, keep the phone on, I'll walk, I've got to drop, where's the nearest Walmart, and finally decided Walgreens, and go down, and all I had to do was buy I think it was a $500 gift card to cover the cost of the transaction. And when I got home, my Ford Bronco would be there. And I forget how many millions of dollars. And he never hung up. He says, I will talk you, right? I will stay on the line with you while you go do this.
How does it drive?
It doesn't, but you can see, and it would be much easier to just go down, and I know the Attorney General's been doing training with stores. You guys, you got someone who's coming in and buying a couple $300 gift cards, especially if it's not Christmas Eve. You might want to talk to them about why they want it.
Yeah, exactly.
Yeah.
So same old scam, a new vector technology. This is just adopted by the big guys.
Fewer human interactions still have.
Still better mousetrap than most smart.
Yes.
Can I ask, I mean, one of the most heartbreaking are the really big financial transactions that someone needs to make. They're supposed to be sending it, wiring it to a bank, and everybody's, you know, making sure that it doesn't get intercepted, and then if it's intercepted, because they set up a portal that looks really similar. Runamuck Maple was a victim to this several years ago, like over $200,000. And at that time, there's nothing anybody can do. Is that still true?
It sort of all depends exactly how the funds, I guess, left. I mean, a lot of time, you might have heard of corporate account takeovers where someone takes over the email account of the CEO, directs, you know, payroll to send $100,000 to this bank account overseas.
Yeah,
It's still very hard once the money is there to get it back.
yeah.
If it's been there for a week, it's probably no longer even in that account and it's gone. So,
Right.
unfortunately, it's hard to say. And nothing that we most here really touched on those bigger situations.
Yeah, I didn't think there'd been any big evolution,
Yeah,
especially with piracy.
sorry?
No, I hope the platforms are doing more warning, dating platforms with it. We had a woman, who not once, but twice got taken, and she just wanted to get it on the record, so that nobody else. But yeah, she was out quite a few $1,000. Okay. Any other questions?
Yes, I'm happy that you didn't mention the thing, business deal I made, where I'm helping an African widow get her dictator husband's millions out of Africa.
Yeah.
They're getting good. They almost got me like, because I used to perform weddings for 9 years as a justice of the peace, and it was like, we sent you a check, but we overpaid you and, you know, I cashed the check and I realized I shouldn't cash the check. I don't know who these people are.
Yeah.
And it was a scam and like my bank account got locked and it got closer because it was so specific. Like, we live here in Burlington and we want you to perform our wedding, like, they have all day to come up with. So
That's sophisticated.
it was really.
That's-
They're very sophisticated. Very. So, no more questions? Okay, thank you.
Thanks for your time.
And you all can just get me a bullet point in each chapter. This is the easy part. Captive insurance is a little more dense. But we're telling people we are going to get two of the longest, driest bills out of the way at the same time.
So,
Now, Donna, you can tell us who you really represent?
I have heard Cynthia Power. 20 years.
Okay, thank you.
Thank you.
Thank you.
All right. Teacher. Committee, once again. I've got a whole wall full of bills that aren't getting any traction. And we need to get them out.
We'll get them out
Or not do it,
Yeah.
we gotta make some decision. Obesity. We're trying to. It's hard to get a number, I've got the state employees coming in to tell us how they feel about being told that they can't find Medicaid.
Right.
But, and I'd also like to ask them, if it's covered in their insurance plan and what it is required, what
Yeah.
that might do.
And as one of the sponsors, I do always want more information, but I'm okay if we're not sort of on the vanguard of this because we're learning from other states how the costs.
Yeah, I think if other states are pulling out.
Yeah.
Getting very limited, I would like to have
Right,
a really tight fence around it.
yeah, so that might even be like a national group that monitors this or like an NCSL, but if, you know, I'm just not gonna keep pushing this one. If we're really, there's too many unknowns.
I talked to him, fiscal note, and he said he doesn't have enough numbers to do a fiscal note. Cause
Right.
they don't know what the uptake will
Yeah.
be, but he thought the 75 million, estimate for Medicaid might be a little high, you know, depending on uptake, you could very easily get there. And that does count against our cap. So we can talk some more about that. 164, I think we've decided we're not doing, that's the deer carcass. They can already do it, I told the sponsor.
Oh, 164 is obesity.
Oh, no, 164. Oh, no, 166.
Oh, okay.
That's the deer carcass contribution. They could do that now. That food exchange, you can't give your brother-in-law a deer and count it as a cheap, even if he's hungry. It has to go to an organization. And whether it's dressed or undressed, I guess, we can give it to the ungiver, but the tax department does monitor that. Six months. Okay.
that's already
Yeah,
law.
we have, yes, it's already covered, it's not need to do, we did 180, so we have taken out 2 bills.
Put John on the floor, top.
Oh, yes, we haven't gone back to this one. The poll attachments for paying programs. We were gonna look at doing an exercise or a streaming fee. So we probably need to talk to Kirby about that. Okay, that one's been slipping through the holes. Yeah, let's tell Kirby we want to talk about ways we might fund this by doing, a surcharge or something on the, streaming sales tax. However we do it. Okay, 182, that's the cows and the metal. I think I heard that. Yeah, the liability of not having insurance, if something happens, you do have to hire a lawyer. Um. But that worked out, and the insurance companies came to a settlement with, and we can argue whether or not it was a fair settlement, but it did get worked out. And what I heard was, if we put that strict liability on the first contractor, that the cost of business liability would go up dramatically.
It's. If we don't do anything, the person who is injured has to give up the money for their injury to the attorney that represents them. When there's insurance policies, the person who's injured gets the payment.
But you can't, do you want to require that all farmers, I mean, this was a fairly rare event. It was suggested that we set up a form of captive insurance, but I don't. If the farmer doesn't have the insurance, that's the risk you take. If you can't afford the insurance, that's the risk. And this was something that no one ever thought of, so it would take some pretty heavy duty insurance, I think, to cover it. I mean, if you don't have insurance, and something happens to you, then you have to hire a lawyer. You might get a pro bono.
If GMP puts something on the pole and they do you damage, GMP has insurance. It's not the farmer that has to have insurance.
No, but GMP, we asked to come in and talk about subcontractors. They were a little reluctant because I think they're afraid we'll mess with them. But they don't. Yeah, no, I know that it would be GMP. If GMP had the South Carolina utility up here fixing wires in a storm, I think it might be the utility. The visiting utility who would be covered, or, that's what we don't know, but no, right now, there is no strict liability for, and I mean, they required you had insurance. The guy did have insurance, it got worked out. There wasn't any fault, EC Fiber got thrown out early on, so it was ended up being between this. The subcontractor and the subcontractor, the guy in the line, and their insurance companies worked it out. But I don't know if you can prevent somebody who doesn't have insurance having to hire a lawyer to slip and fall. I don't believe I have to have homeowners insurance once I've paid off my mortgage. I'm taking the risk that my house burns down, or that somebody slips and falls in my front steps.
When someone acquires right of way for utilities to go through your property and then comes on your property and damages you.
Their insurance company is liable. Well, their insurance company paid this time. Or the combination of insurance companies paid. What you're asking is that the person that didn't have the insurance, you need to get somebody to advocate for you. Who advocates?
In the case of Tunbridge, we don't know who paid whom.
We never will, because that's the norm. You don't have insurance settlements people get. I'm sure the guy that hit my car out here in the parking lot doesn't know what kind of insurance settlement I got. That was very expensive to pay some time. So can we, on this one, do we want to go further with it? Do we want to?
I want to explore it further, because I'm not sure of what happened, how much of that had to happen, and how much of it could have happened differently, and what those different scenarios might have been.
Okay, but I think if there's a settlement, I don't know if there's a confidentiality. settlement. And it sounds like some pieces of stainless steel wire got dropped in a pasture.
No, I
The
remember.
farmer, yeah, did the hay. His magnet that is there to pick metal up out of the hay didn't pick up stainless steel. And so it got mixed in with the hay, the cows ate it, and I think at least 2 of the cows died. Several of them were sick.
Yeah.
And this is a small farmer, and it was a burden. If they hadn't been a small, poor farmer and had, I don't know what kind of insurance, then their insurance companies would have fought it out.
What I'm gonna say, I knew that, because even though it's Mark's jurisdiction, I live right nearby.
Yeah.
And so they knew me personally, and I
Yeah.
recall. What I don't know, the information I'm is the actual machinations of the insurance companies. Okay, it was what happened after all that.
Okay,
How did it come down? Because, you know, there are times when a story has a happy ending, but only because someone decided to do the right thing. They didn't need to.
okay,
Maybe, you know, had they decided otherwise, they would have been able to.
okay. But I think we've been told DFR won't talk about it. They know what goes on. The insurance companies don't reveal their thinking and their mechanizations. So you buy the insurance and they defend you. So you've got all the insurance companies defending their people. And I guess they risk being taken to court. But that is very expensive. And so the farmers are under the pressure to do something. If we make this strict liability standard, and no place in the country except New York City and scaffolding has strict liability. We learned that with the Bennington case, when we took that in here, when I sold out to the military industrial company. And we passed that bill out again, but strict liability, if you say that under all circumstances, EC Fiber is responsible for what their subcontractor who they've worked with, who has insurance, what they do, and then what the subcontractor does. And, you know, we're working with one situation. The next one, the farmer might have let the cows out into the road. You know, you can't. It's hard to make a law that will cover every situation. It's something like insurance, and that's why you go to court and you work it out. That's why we have workers' comp. So that.
Well, workers' comp's the same problem.
No, workers' comp is, and despite the fact that this committee, when I wasn't here, tried to undo it. The deal is, you get immediately the help you need, you know, for recovery and food for your family when you're injured, and you don't have to take the time to fight to go to court to get the money you need to feed your family today. The trade-off in that is you get this. What you can't do, and what is trying to be do, is you can't then sue your employer for pain and suffering. And if you want to do that, then everything is at risk. So workers' comp is set up to get money to a person when they need it the most, when they're in traction. But it protects the insurance companies who would probably fight you. They did. That's social
The
contract.
workers' comp problem was when a contractor hired a subcontractor. And the subcontractor had someone come on the job that was not insured. And someone, the original person that hired them, or the subcontractor, didn't have the insurance they were supposed to have. The person who was injured was taken care of, got the services.
Yep.
But the entities that caused that person to need the services, somebody didn't have to pay workers' comp.
Okay, well, then that's something we do in workers' comp.
Oh,
I am,
misclassification
Yeah.
of worker.
Well, that's a different thing, where
Right.
the moving company has you know, 99 out of 100 people working for the roofing company
Right.
or secretaries.
Oh, yeah.
Never go on a roof.
Right, so
Well,
just
we would check that, I'm sure.
Wasn't there like a compromise about trying to,
There's been a lot.
okay,
no, I just mean, someone brought up something about like making sure the insurance is easier to find, like
Oh.
their insurance.
DFR testimony was that they have been working since this incident to see if they can find a way not to have it happen. And they are in the process of setting up a portal
Yeah.
where an employer can look and see
Yeah.
if their subcontractors really do. And if you really don't trust them, I mean, this one, the rumor was the bottom guy, the sub had let his insurance lapse on the last day of the job, which,
Last day, first day,
no, but,
it's equal.
no, I believe if the insurance was in place when the evil happened, he's liable. He was, all the insurance companies were there. So I'm not inclined to do anything in the realm of strict liability. I think it could end up pricing the cost of property, business property casualty insurance out of the reach of the small contractors that you want out.
I'll give them a call and tell them what the dilemma.
Yeah.
Facing it's
Yeah.
the folks that own the dairy farm. Came up. Yeah, they were not made whole.
No. I think, yes, that's the realm of insurance. And if they had insurance, they probably would have done it, yes.
Last question, real quick. Can we meet with Kornheiser Wednesday at 1?
Yeah,
I just, oh, cause
wait,
it's.
wait, Wednesday at 1,
Yeah, Thor.
I can meet, no,
Floor at one.
I can meet with her, no, we're on the floor. No,
Tuesday.
Tuesday at 1, Wednesday,
She said, if it's Tuesday, it's at least
Tuesday
late
at
as
9:30.
possible.
Wednesday and Thursday, it's at 1. And I have money chairs, but, oh, she'll see me at money chairs. Tell her no.
This is talking
I don't know. She
Property
will-
taxes.
Yeah,
in here.
well,
Some,
we had her booked in here yesterday, which I think is why I got the 100 calls and
oh, right.
this is the latest thing.
You were getting more calls than I think the rest of us. Let me email.
My husband said there were 100 people.
On what?
Stowe, the superintendent,
Oh.
Stowe was looking, according to their calculations, at a 40%. Montpelier, they're going up 19% in spending. Montpelier is going up 23% in spending. The result is that I don't know that I can absorb a $2,000 to $3,000 increase in my property tax. And there's a lot of people that can't, and I'm not sure. It has been suggested that we cap spending. Would be very unpopular.
Where you cap spending, not spend money? Can you imagine us doing something like that?
Sarcasm.
I know. But I mean,
Article
we're
18 of
looking
the
at,
Constitution, again, using the word frugality and moderation.
our ancestors were very much into frugality and moderation, at least my Yankee ones were. Anyway, that's, she's gonna brief us on what she thinks she's voting out today or Tuesday. So we should get it, if they get it through the House, but that's just the spending on the weighting, the change in weighting, and they will, as we did when the bill left here, phase it in over 5 years. But they all last year already gave the winning towns all their winnings in 1 year. So but that's just the weighting issue. Then the schools have this perfect storm. And I'm trying to get a number on what the average school budgets are, but we're usually talking, a couple, we're not talking anything like this. We're talking 10, 12%, maybe 7 or 8. we're gonna have a problem. Because people who can't pay their property taxes are gonna end up having their houses taken for tax sale.
Yeah.
Which is not something I think you wanna have done. So
It's a housing problem, at the same time that it's solved.
we are creating a bigger one.
We need more help.
We're working on it.
Modify the eviction proceedings in the housing bill. It's gonna come to a lot of people who they won't be able to pay property taxes.
No, they'll get, well, the rent will go up to reflect the property taxes, and
Same
yeah,
thing.
they won't pay it, and the houses will go for tax sale. That is not a good thing, and we're gonna need to get our hands around it. Okay, we're gonna talk to Kirby on the next one, we did credit unions. We did contractor liability. Related to merger, okay, we probably need to we've got one witness today at 2:30, is she?
She's on
up
Zoom
there?
right now.
Okay, we've got one more witness on the mergers. I think if we get new language on the treasurer ability to delegate. Okay, so
Hello.
we back, hello, and welcome. Sorry that
Welcome.
get to you yesterday, but we don't always control our schedule. Ellie, just introduce yourself for the record and tell us what any thoughts you have on the CUD mergers and so, yeah. Communication, yeah, mergers and governance.
Mergers and governance. Thank you. So for the record, my name is Ellie de Villiers. I'm the president and chair of the Vermont CUD Association, VACUDA, and I'm the executive director of Maple Broadband, which is a communications union district of 20 towns in Addison County. So thank you for the time. So I know you folks have had a read through and you heard testimony from FX Flynn in the last couple of weeks. So obviously as VACUDA, we support the bill. The changes in it are, some of them have to do with the flexibility of dates, because as FX said so well, not every CUD wants to have its annual meeting on the second Tuesday in May, and so just having flexibility to have things like the draft budget and pro forma going out to member towns with some flexibility in terms of when that happens in the district bylaws, and so there's the reasons for that, I think, are fairly straightforward, and the provision around electronic meetings is also really just because it can be challenging when you have a district of, forget the NEK has 45 towns or something like that, 51 towns. Getting everyone together physically is really simply not practical. So that change as well. And then finally, I think the bigger one is around providing an improved mechanism for mergers. And I say an improved mechanism because there is, under the current statute, there is a way for CUDs to merge, which is that every town in one could vote to join another, and then the towns in the merging CUD could vote to dissolve the CUD. But it's that is an onerous and cumbersome way of doing it. And so the intent with this is to provide an easier and more streamlined way to do it, because it's the sort of thing where you want to have it in place before you need to have it in place. And in particular, as you folks know, because we talked about it previously, the federal grant program, the BEAD program, is happening this year, and it may well be the case that some CUDs decide that they have, because it's a competitive grant program, so they may well decide that it is in their best interests to merge the district in order to bid on BEAD. So for all these reasons, we want to have a mechanism which is well understood and which is able to provide a relatively rapid way of accomplishing that, but with all of the appropriate oversight. So again, I'm sure you folks have read it, and the merger process requires 2 affirmative votes by both boards. The first one, the preliminary merger plan, is 75% of delegates, and then the final one is 2/3 vote. So I think those are the high level changes in it, but all of these things are really just meant to streamline things, and then again provide a mechanism for mergers which can allow them to happen in a rapid form.
Okay, thank you. The one largest concern this committee had was on the ability of the treasurer to delegate his or her duties. We're looking for some language to tighten that up. We could see delegating you may have somebody that wants to just keep your books, but you may, if you're a larger CUD, somebody that's doing more financial management. And you may want to hire a bookkeeper to, you know, keep your books and balance it and pay your bills. Does Vaikuda have any thoughts on that?
Yeah, so that's a great point. So the changes to the treasurer role are for exactly that reason, that we want to provide some flexibility. The intent is for the treasurer always to have responsibility and oversight, but to create more flexibility in terms of how that is accomplished, rather than the individual himself or herself having to do the tasks. And I think that's the prior. Sorry?
I assume the treasurer is a volunteer position.
The treasurers can't, some of them are volunteers, some of them are paid positions. It's really a mix. But I think that I did listen to the prior testimony from FX Flynn on that, and as Vaikuda, we actually think that the suggested wording to change it from responsibilities to duties is actually an improvement. So we would support that modification for your discussion.
Okay. Questions from the committee? I don't see, Senator Gray has one.
I'm just thinking about, back when it all got started, Senator McDonald was here and I was on Gavad. And, it was I suppose in retrospect, it's a cumbersome mechanism because it was very much oriented to things like, vote in towns to amend their charter and things like that. So it has that sort of slow moving side to it, so that it would be like careful evolution as opposed to sort of, hey, we have a business decision to make and now we're gonna merge something that involves 24 towns.
Well, yeah, I mean, to do a vote, unless the town's willing to pay for a special vote, you're gonna have to wait till town meeting. But if you want to bid on a federal project in July, you don't want to wait a year to get 51 towns to vote yes. And 51 towns, all you need is one not to vote yes.
Right, you end up with the one town out.
Yeah.
But I say all that by way of explanation, and I think, this was already like 8 years ago, and things have changed so much. Now there's actually, it's become happily much more
Yes.
businesslike, where you might need to make more nimble business decisions as opposed to sort of just a municipal function like any other government function.
Where are we going to find the desk? Where are we supplying it? I mean, 2 years ago, that's where we were. We found a room in City Hall or the library we can use. So they have come a remarkable way. Okay. Thank you, Ellie. Thank you for all the work you've done to make this such a success. It is, I think, more than we ever imagined. So
Well,
that's.
thank you.
that's good.
Thank you very much. It's still very much a work in progress, but at least
Oh,
we
yeah.
can see that there's very good progress being made and the future looks bright.
I think like captive insurance, as you grow and develop, you may have to change some of the rules and regulations to allow you to do that.
Yes,
So-
exactly. Very much. And thank you very much to the committee for your consideration of this bill and for your support of CUDs in general and broadband in general.
It's our job. Thank you.
Thank you very much. Have a great afternoon.
You too. Okay. It's Maria that drafted that. I'll see if we can't just get some tightening up language and we'll put that on for a vote. Medicare Advantage and supplements. I've asked MVP and Blue Cross to come in and talk. They also have Medicare supplement plans. Which I'm told are run entirely differently, so we'll get their take. But since an awful lot of this is federal regulation, I think we'll try DEVA, unless we have to call Washington, to find out, it seems to be the cost of getting out of the plans. That's the hindrance. And that's, you don't get community rating if you go in as a 90-year-old heart patient, you're gonna pay, through the nose for that supplement plan. I don't know if that's a federal regulation we can do anything about, but I think that's that's where the roadblock is. It's whether or not we like Joe Namath. We'll have DMR, they can talk to us about what they can do about advertising. I'm hesitant to forbid brokers to sell them in this state because that's the one place we have the power to ensure that the appropriate disclosures are made, so they know if they get out, they might not be able to get back into Medicare with anywhere near the appropriate coverage. I'm gonna have the state employees in to tell us what they think about being told they shall never be allowed to get a Medicare Advantage plan because they might find a Blue Cross local developed one that is better.
Well, that's what they had the opportunity to have and they didn't like it.
I think it was imposed from above. They, it never got to what was in it. It's how, I have a feeling they might react equally violently to us.
Well, I think, but based on everything I've heard from the BSCA, they obviously have lobbied it, is just the concern that we talked about in here, that everything is fine until you get sick, and then there are networks in the Blue Cross programs, et cetera, as well. It's less onerous than many, but I think it's just an inherent suspicion.
Oh, yeah. Yeah, I think, and the biggest reaction came from the retired employees, many of whom are old and like the program they were in and didn't want to have it changed. So, yeah, anything you give, we probably have to start with this year's and phase up. But I want to give them a chance to tell us if they think we should tell them they can never do it. Because ever is a long time. And yes, and then there's the big one. 248 criteria. I tried to get the regional planners to come in and talk, but one of the slides we saw this morning were areas in which wind or solar are not allowed in the state plan. That's mostly the mountaintops, a few wetlands. I'm not sure what to do with that one. I'm hesitant to give for-profit businesses free rein without the ability of the community, and it sounds like this, aesthetics is the only place they can get in. We can ask regional planning how many towns have appropriate siting places and how many utilities have gone on them. My sense is probably not many. But I don't know.
Well, the thing that struck me is the testimony that we heard is that one incident in which aesthetics had played a role. And is this a problem worth trying to solve?
I think the problem is that that's the end the neighbors get. And not that they win, but that they slow down the process, and time is money. And it's inconvenient to have.
But at the same time, I look at my property, for example, if somebody wants to put, a major wind or solar operation across, the road from my house, I'm gonna scream that, I can't see the mountains, I can't see the field, I can't see anything except for solar panels.
Yeah.
And if you tell me that I don't have the right to raise an objection, I'd be concerned as a property owner.
Senator McDonald.
So the testimony is said that when should such an event happen, whether it was because your town plan either permitted it or didn't. That's the deciding factor. And you have the opportunity, one has the opportunity to weigh in on their town plan. But if they don't, it's the town plan that decides.
Person isn't gonna raise anything about a town, in an amorphous town plan, on an event that they don't anticipate happening.
I mean,
They're gonna wait until they're confronted with it, and then they're gonna say, when they get the notice, oh my God, this is what they're gonna do to me,
Yeah.
what can I do?
And I think we heard Brooke Dingledine just talking about Warren, which is not a for unsophisticated town.
Mhm.
And they had in there, you know, there shouldn't be, or there should be citing here and not there.
Mhm.
Well, unless you say shall, you don't get, and so we say you're supposed to have this in, but these small towns don't have the ability to.
Yeah.
To. They just don't have anyone. You got three guys who might be farmers on the select board, and what do they know about utility siting? Or that it has to be there, and so we need to have a more robust, I hate that word,
Robust.
well, somebody used it every 20 minutes.
Oh, right.
Thank you
Is it
for saying
okay?
that.
Right, Commissioner Brady.
Knew I hated that word. But yeah, we need to do a better job of helping towns with it. I mean, this new housing tiered mapping, we're gonna be asking an awful lot of towns and especially,
And so, the fact that it's taking so long for us to understand it tells me the average person confronted with it is not gonna understand any of this stuff.
Well, I'm fine with not moving this forward. I just would say if it does move forward, I think it's better that it would be narrowed into where there are comprehensive town plans, not robust. But there are, I'm a fan and I've seen town plans do a really good job at telling
Yeah.
people and homeowners what will and likely or possibly might or might not occur across the field. So I see town plans as very effective tools to set expectations for people.
It
So
is.
if it moves forward, deference to the town plan in some way, I would support.
I tried to get it into the mapping, but they declined.
If you include, in effect, the instructions that realtors have to ensure that new buyers are aware that the town plan that may affect them, and they should look at it before buying.
Neglects to
You would better
discuss.
bet that will show up on the realtor's list.
Because a lot of the house that usually does, they say there's a road that's planned here, and so you can expect us to come in.
But,
You know, this is where the solar panels are gonna go, and over here is where the nuclear power plant will be.
yeah. And so, and nuclear power would be good renewable power, so. I mean, we closed down the, but,
We're talking nuclear.
Other wells.
so,
Yeah, I start with, the aesthetics matter. I think at times the issue is treated as though you got the real issues like commerce. And then which is a real issue, but like that's the only real issue, and then there's those aesthetics, don't be silly, we've got work to do. And I count that aesthetics really does matter. It's what makes us civilized in the better sense of the word. And it's not just a matter of the fact that I think there are people, Randy has articulated as well, there are people who have a legitimate property interest in aesthetics. And, but I think besides the fact that there are people with legitimate interests in aesthetic questions, I'm risking sounding poetic here, but, I think Vermont is a place of value, of aesthetic value. And we're inheritors of that beauty. And with that beauty comes a duty, and comes a responsibility. I think we owe it to Vermont, which sometimes I like better than I like the people here. It's just the Vermont. It's our job to take care of. And it's taking care of us.
But I guess what I would just say to that is, yeah, but I would say that, not in disagreement, and I think town plans can take care of that.
Yes.
And then when they say for more developed areas, like where a lot of my county are, if they say this is where the solar panels are gonna be, then I think aesthetically, we can count on that and use that.
Yeah.
To know that that's gonna happen in the future, but I think we come from an area where there's less clarity on the town plans and definition, and absolutely, we need to be some stuff.
I would just articulate where my feet are standing for this, but I think we really do have to get into the mechanics of what I always say, if you don't want the solar collectors there, then where do you want them? And that's a legitimate question, and that's to answer it before there's a controversy.
It's the town plan.
Hence the town plan.
Okay, so
So-
we need about we need to do a better job of helping the towns identify. And, just because the town has a plan, the facilities are gonna wanna go with this three-phase power because it's expensive to run it out to town. Thus Route 7, because the power line is there. And so,
And on the land,
Phase number just keep over.
okay, Cedar Frame, I didn't.
Yeah, that's it. On Route 7, I think that phase, no pun intended, is over. We're not gonna keep piling on. I mean, hasn't been anything for 5 years or more, but, well, so you were saying it poetically, you were saying in prose, and the other piece that goes, to recognize. It is hard to talk about aesthetics, some people think you're just talking about fluff or something, but. And the National Historic Preservation, no, it was the UN has a body that identifies
Story,
places of historic value.
yeah, well, it's a world treasure center, so.
Yeah, and they identified the state of Vermont as a whole as such a site like 12 years ago. Because it was a unique place in terms of having maintained its village centers, green spaces. It was a common
People
thing
wanna
once,
come here.
and it has disappeared for a lot of places, so.
Our natural splendor, I have 3 that I have.
Okay, we're fine. Okay, I have been through, I think I know how we can start getting some bills out of here. Because, and we got a new one today. Which they're talking about crimes and liabilities but we got the, motor vehicle, major vehicle, so we will schedule whoever the drafter is, Anthea maybe. In to tell us what our parts of that are. Last time, I think we had two paragraphs in a 20-page bill. So we'll find out what that is, but probably,
She sent a note, it's really a nothing burger for us, I would expect.
yeah, I think we can probably get it in, put it on the next day to go get that.
I think it's good that the chair of the Natural Resources and Energy Committee serves as well on the finance.
Oh, yeah.
Okay, that nexus is important. And this is an energy issue, it's a natural resources issue, and it's a finance issue.
Which issue are we talking about?
The placement.
Oh, okay.
Well, and to your point about maps and supporting municipalities, so not only are we looking at maps and supporting municipalities in all the Act 250 work. We're doing the very same thing on river corridors, floodplains, wetlands and dams and emergency action plans for dams.
We're going to get this all together, and I sit there every morning and remember that old adage, man plans and God laughs.
And I love
Laughs.
Where's that, who said that, you know?
No, but I've heard it more than once.
Women plan too.
Yes, it was a generic human.
Thank God.
We are planning everything and that's. Yeah, but if we give we've come a long way with the towns, but we really need to have more technical support. I mean, they don't even have a secretary that can type the notes. We need to,
Not all towns are equal, because,
No.
yeah, that's,
you're a city.
so towns tend to be a certain threshold, like it's a senior deference, but that's the way it feels like you're going with this.
So we've been in natural taking loads of testimony, learning about management of what rivers do, how floodplains behave, the laws around them, which are federal and state and municipal, and trying to figure out how to manage them well, because it's really complicated and dynamic.
You should be on the trip to Barry to look at the debris stuck under the bridge.
Yeah, and so to your point, it's like, even in a sophisticated town, the amount of science that is behind, figuring out what rivers are up to, and I guess I can see how, I mean, to me, that's one of the stronger arguments for state management in consultation with the municipalities, but because most municipalities aren't gonna have a river scientist on tap or it'd be
The
expensive
Army
to
Corps,
have one.
we have a river out Elm Street coming from the Wrightsville Dam that was doing this really strange curve and taking out the hill that supports the road that a lot of people live up on. And the Army Corps said, nope, you can't reroute it, it won't work, and we ended up putting thousands of dollars worth of riprap and wire cable on that hill just to keep the road from eventually ending up in the river. And it was at least one house right on that edge.
But I have to run, but if we want to have clearer paths for renewable energy to be built, some of these kind of plans are very sophisticated, and
Yes.
as sophisticated
Yes.
as anybody else is gonna get, so giving efforts to those to allow for clearer paths for renewable energy is something I can support, but I'm not. pushing
Yeah.
for.
No, the other thing in the plan is we've gotta have the ability to get it out.
Yeah.
We've gotta look so that towns can afford, or utilities can afford to buy it.
Great.
Okay,
If the now is the financial responsibility of the builder, so they often try and locate where they can get it out.
well,
Less expensive
We've got that
and smooth
little-
sailing.
yeah, we've also got that little bottleneck up in the kingdom where we're shutting down the very controversial windmills because we can't get their energy out because we've got all of the net.
Maine has figured
Community
out how to
solar,
use
is
that.
that it, where they sell 20% to the local school and then everything else gets shipped to the grid. And we can't get it out. And they have to buy it. So we have some corporate shared welfare going on.
Well, do you want your committee to be looking at that? You should be.
I think it's the committee next door that will eventually look at it. I mean, we have regulations put in when solar energy was an emerging technology and they needed guaranteed markets to afford to put stuff up. I don't think it's emerging technology anymore, and we may need,
That was back at Stanford. offer.
yeah, it's standard.
Now
operating.
you have to go to get it. Permission to build, you have to be able to produce power at a lower price than the competitor who also
Okay,
wishes to be chosen.
we have not heard any of that in here, so we probably need 101, renewable energy today. Okay. So thank you, have a good weekend,
Thank you, Madam Chair.
come back, because next week's not gonna be any better.
Well, we'll probably have some really simple bills like BAA coming in.
That was a simple bill until it got into, it took so long to get both of those concepts going. That, I mean, we started cannabis back in 2015, I mean, it took like. I think over 6 years to get the House, and we had a bill and they wouldn't agree, and it took a long time, but that sales tax for cannabis was always in there for after school as a prevention program, not as an education program.
That wasn't what it is.
No, I know. What do I tell them? We're gonna cap their spending.